Hello, and thanks for joining us today. As part of our series of interviews with top legal minds in family law, we are very pleased today to spend some time with Brian McNamara from McNamara Law Office. Hi, Brian. How are you doing?
Doing well. Thanks for inviting me, Victor.
So, we're really excited to talk with you, Brian, and we're going to focus today a little bit on mediation. But first, let's talk a little bit about your background as a family lawyer. Brian has been a lawyer since 1992, and throughout that time, he's always practiced family law, mostly in the Texas area in Harris and Montgomery counties. He's been operating out of Kingwood since he opened his doors in 1992. The state bar has a college of the state bar for lawyers who take much more continuing education seminars and courses than required. And after 10 consecutive years in the college, Brian was designated a fellow of the College of the State Bar of Texas. And after 25 years as a fellow, he became a member of the Society of Legal Scholars. And in the 30 plus years he's been practicing law, he's handled countless family matters involving estates of all kinds of different sizes and every issue imaginable. Brian is an experienced and well-established attorney, and he has 5 stars on Google and Avvo.com. So he is a well-qualified attorney. All right, Brian, let's just jump right into it. Our topic today, mediation. So could you explain to our audience what is mediation in the context of divorce, and why is it gaining ground as an alternative to going to court?
Well, thanks very much, Victor, and thanks for that glowing introduction. Mediation is it's not necessarily an alternative to court. In Texas, where I practice, it's required by most judges before you can have a contested hearing or a trial. So in most cases, before trial in family law cases, the parties have to first try mediating. And mediating is where a neutral third party tries to help them reach an agreement. The typical format when a case has already been filed is that party and lawyer is in a room or a Zoom breakout room, and party and lawyer is in a different room or a Zoom breakout room, and the mediator, who is neutral, visits back and forth with each side trying to get an agreement. If an agreement is signed in a family law agreement in Texas, it's binding, it's irrevocable. That's the benefit of the day. The benefit of taking a day off and spending the money to mediate is you get a binding mediated settlement agreement. And that's the typical process.
Right. Well, one of the key benefits there is the ability to maintain some sense of control over the outcome. Unlike when you go to court in a typical sense that you think of or see on TV. Could you expand on that and how that's beneficial to a divorcing couple rather than having a judge make those decisions for you? Mediation is a way to try to work with each other and come out with a better outcome.
Oh, absolutely. So the way court is set up is we basically say we're going to decide issues about children or end a marriage in basically a forum that was set up for contracts and car wrecks. Okay, we're going to go to court. We're going to use the same rules of evidence that apply to car wrecks and contracts and civil cases, injuries, and we're going to use the same rules of procedure. And it's not, in my opinion, it's not well suited to ending a marriage or even deciding what's best for a child, because under the rules of evidence, the judge or a jury may not hear everything they ought to. And so the people sit in a chair, lawyers ask them questions under controlled conditions that limit what the lawyer can ask. The witness is allowed to answer within certain constraints. You can't venture beyond the course of the question. And then the decider takes that in their brain and spits out an answer. Well, there's no way that someone can understand a person's life in that process. So by going to mediation, parties have an opportunity to have much more control over the outcome and how it works out, rather than leaving it to in most cases, a judge. And judges in Texas are lawyers who won an election or two. They won a primary and they won a general. There's no other qualification. So you're not necessarily getting someone who's terribly well qualified to decide what's best for your life. That's the big benefit of mediation. Also, it saves a lot of money if it's successful. If you make a deal, it's an expensive day, but it's much cheaper than a trial. So those are the primary benefits.
Yeah, well said. Could you touch on how long the process would typically take? I know there's probably a lot of variation there, but once again, for the viewers, what kind of timeline would they be looking at?
Sure. So, all right. So in Texas, um, you can be, many courts might order in a divorce. Well, first of all, let me back up and say first, before you can have a trial, most courts are going to say you have to mediate. Now, most cases are not ready for mediation until several months into the case. It depends. It really does. The issues of children can often be mediated earlier just because we don't need to gather a lot of information. But property issues, estate issues, property division might take longer to be ready because we have to gather information. We may need to issue subpoenas to banks if people aren't exchanging statements. We may need to issue a subpoena to a retirement plan if we need to know what's in the retirement account. So that can take some time to get it ready. Once it's ready, typically we schedule a block of time, either 4 hours or 8 hours. They can run over if progress is being made. And during that block of time, whether it's a half a day or a day, everybody is required to give their undivided attention to trying to work through these issues and reach an agreement. And a lot of it depends on the quality of mediator, but that's primarily what how the process works. So as far as the timeline, oh, one more thing. As far as the timeline, it can be several months in. It can be closer to trial. It really depends. When a case is first filed, a divorce particularly, a judge may issue a temporary order. Temporary order has to be requested before it can be issued, and it says what's going to happen while the case is on file. It governs the circumstances while the case is on file. For example, if a couple says we cannot both remain in the house, but we can't agree who's going to leave, the judge can tell them who's going to leave temporarily. It doesn't decide the outcome of the case, just who gets to live in the house. If we have kids and we can't agree on support or we can't agree on who's going to see them when, a judge can issue an order for that. If someone leaves and doesn't help pay the bills, the judge can order them to contribute to paying the bills. Before temporary orders can happen, many judges require mediation. So it is possible to have to mediate twice in one case. Once before the temporary orders hearing, if one is requested, and second, before a trial. If you cannot reach an agreement informally and you say, Judge, we need a trial, the judges are going to say, first you mediate. If you can't make a deal there, then you get a trial.
Now, Brian, can you act as the mediator in some cases? If there's a couple, we have two parties who are somewhat agreeable as a basis, are you able to assist in a situation like that?
Yeah, so I am a mediator. I have taken the course and qualified as a mediator. But one of the things that I offer, not many mediators do, is to work with. You can have a couple where neither one has their own lawyer. I cannot represent either one of them in that instance. I can be the mediator to try to help them reach an agreement. We can even do that before the divorce is filed. So if they say, look, they've come to the conclusion a divorce is going to happen, whether both want it or not. If they've come to the conclusion it's going to happen, I can mediate with them before the divorce is even filed to try to make an agreement. The process I use is a little different from the one I described because there's no lawyers involved, so that can take several meetings. Instead of just blocking out 4 hours or 8 hours, we may have an initial meeting where we talk about if what we agree on, what we can check off that's agreed, and then what we need to resolve, and then what information we need to resolve it. And then the next meeting may be, okay, so go away and get this documentation, and then we'll meet again, and we will deal with this issue once we have that information. Sometimes it's done in 2 sessions. Sometimes it's done in one if they're not really that far apart. So I've had some that went 3 or 4 sessions. It just depends on how far apart people are, the size of the estate, what the issues are, factors like that, and emotion. If someone's not ready for the divorce, it may take a little longer. But that's something I do work with people on. But I also attend a lot of mediations as an attorney representing a party at mediation.
Excellent, excellent. So, is when you think about mediation, I know it can be scary for couples, and is it only for somewhat wealthy individuals with businesses to divide up, a vacation home, a
No,
boat, or is it also something that's a solution for more down to earth folks who are more modest means, middle income folks like that with a home and maybe a 401k? Um, is that right for them? And also, how would you work with couples like that?
no, mediation is good for everybody because trial is very expensive. So, in fact, many counties, Harris County, where I practice, and Montgomery, I also practice in Montgomery County, which Texas, they both have facilities that offer low cost mediations for low income individuals because um, yeah, if you have a lot of property, you have some more stuff to fight about. But that doesn't necessarily make it an easier case on the property side. Certainly, anybody can have kids and disagree about kids. You don't have to have wealth to disagree about your children. So, mediation is very successful for issues involving children, and uh, with regard to, so it doesn't matter how much money you have. It's very helpful because if you don't have a lot, you may not be able to afford to go to trial, or you could be representing yourself at trial, which is really not a good idea. So mediation is very good for that. Um, as far as the property side, it doesn't really matter how much people have. I mean, if somebody has a house and a retirement, that's, you could argue, more important than someone who has millions of dollars. I mean, when Bill Gates' wife consulted a lawyer and said, we're getting divorced, they could guarantee her she would get at least $1 billion. I mean, that's a lot better. Like, you're guaranteed you're going to get $1 billion. We don't know how many more than a billion, but you're going to get that much at least. Versus someone being afraid that they may not have a house to live in, or they may not have any retirement. So the size of the estate isn't necessarily what governs how important mediation is. So no, it's used for everybody, and because it's so successful, is the reason most large counties or metropolitan counties in Texas, at least, have some kind of a low cost option for mediating based on some kind of a sliding scale, income based.
Yeah, the stakes are pretty high no matter what the income level, but certainly if you're of more modest means, it, it's even more important, I guess, because you're living in this house and that's your big asset. And what are you going to do moving forward? So I see what you mean.
I don't know if it's more or less important, but it is important, and
Yeah.
but it doesn't matter. I mean, sometimes people are trying to protect a business they spent their life building, or someone can be had been has stayed home throughout the marriage, and now they're over 50 trying to find a job, and the biggest concern is health insurance. I mean, that's it. People don't realize that that's a huge concern for someone who's over 50 but not yet eligible for any kind of Medicare, and in between, it's hard to find coverage, and especially if you don't have any work history. So there's lots of variables, and mediation can usually resolve those. Um, Personally, I believe it's a very good idea to try it in lieu of skipping, going straight to trial. And it's been, I'll just tell you, mediation has probably been around big in Texas about 25 years, give or take. And I've been a lawyer for about 32. So it came into vogue shortly after I was licensed. And there was a couple of times as a new lawyer where I filed a motion and asked the judge to excuse us from mediation because this case is never going to settle. Everybody's too far apart. It's just not going to happen. And in some cases, my motion was denied. The judge said, go mediate. And some of those actually did resolve at mediation. So I no longer file those because it's just simply too hard to predict. And any lawyer who's got experience in will tell you that we've had cases that went to mediation that we were certain would be resolved. I mean, the issues are just not that big. And they just didn't get there because of personality or someone doesn't want a divorce, so as soon as they agree, the divorce is going to happen. So they just continually move the goalposts and don't agree. But that's rare. More important, the fact that you can have obstacles does not make it something that should not be tried. It absolutely is worth doing and should be tried.
Over the course of that 30 years of experience, you've learned a thing or two, I can see. Earlier, you touched on the process. When an agreement is made, the mediator circulates it out for signatures, then provides everybody with a copy, and it then becomes irrevocable. So it is really important to have a good attorney because this is set in stone moving forward. So could you touch on a few of the strategies you like to employ when working with a client to make sure this process moves fairly smoothly, like good communication, the ability to work together, to compromise, that kind of thing. Could you touch on two or three tactics that you like to employ with a client?
What we do in my office, and I'm amazed that the majority of lawyers don't, is we always send the mediator a confidential packet in advance. We write a letter, a confidential letter to the mediator, telling them about the case, about our client, and about our client's concerns, and why uh, the strengths of the case, and also if there's weaknesses, we'll bring it up because it's better to hear it from us than from the other side. And then we usually include with that letter that's emailed, and then we will send them a link to documents so that they have all of the important documents in the case. Good mediators read that in advance. Some lawyers who mediate a bit on the side but don't take it too seriously, sometimes I can tell right away they haven't read what we sent them. But the majority do. When time permits, we try to send that to our client in advance. Well, we send a letter to them in advance no matter what, just so that we're not asking for something they don't want. But it also helps to kind of clarify in everybody's mind what it is we want and what we're trying to pursue. I don't ever draw hard lines in the sand or say, there are some instances I would say where we might do this is a bottom line, we're not going below, but it's very rare simply because in most family law cases, there's just so many moving parts. So if
Mm-hmm.
someone says there's no way that I will agree to X or that I will give up Y, and I say, well, what if they offer this? And they go, oh, well, they're never going to. But if they do, oh, well, then I might give up X or Y. So it's very hard to draw a line in the sand because we don't know what's going to happen. I don't like to do that in advance. But obviously, I discuss with the client what's important and what they really need. Um, Sometimes, if someone's in school and going back to get educated so they can get employment, they either have to have some spousal maintenance or a minimum amount of cash from the estate to just be able to live while they do that. So we know that's essential. We make that clear to the mediator up front. So every case is different, but that's kind of how we prepare it. I do have information on my web. I have a whole page on my website, McNamaraLawyers.com, about mediating. And there's some material I've written and put on there about how to prepare for mediation. There's a lot of downtime, I tell people, because the mediator could be with the other side for an hour or even 90 minutes or more, just exploring issues and negotiating with them. So during that time, have something to do. It should be something entertaining but not work related because you need to be focused on mediation. You don't want to be distracted by your job. Uh, get a good night's rest before because it is a stressful day. People come out of mediation feeling very drained. Despite the amount of downtime, they feel very mentally drained. It's a stressful day. So, good breakfast, sleep as best you can the night before. Of course, it's hard to sleep the night before your mediation to end your marriage or whatever, and I understand that. But you get as much rest as you can, get a good breakfast, bring mediators are going to have water, but if you want to drink your own water, bring a giant jug of water and be prepared for downtime and let the process work. Don't walk in thinking you're going to walk out an hour later. Let the process work. Those are the expectations people should have.
Yeah, Brian, you do have a lot of good educational resources on your website. So I would invite any viewers in Texas, especially in Kingwood or the Houston area, to check out the website and explore the information. It's a good start to the process. So do check that out, please. And Brian, we've been talking about mediation here. As we wrap up this particular interview, could you just quickly review two or three of the major benefits of the mediation process? I know it's required in Texas, so you're going to have to go through it. But um, as a viewer and a person potentially seeking out a divorce, what are some of the words of wisdom you can offer them as they take a look at the mediation process?
Oh, yeah, thanks. First, let me just say, as far as where we cover, you had mentioned about Kingwood and Houston. I'll just add that the lawyers in myself and the lawyers in my office are members of the Houston Bar Association and the Montgomery County Bar Association, and we all have courthouse badges that we pay for to get in and out of to skip the metal detectors in downtown Houston and Conroe. So we do Montgomery County and Harris, and then we also get out to Liberty County now and then, a couple three times a year maybe we might get out to Liberty County, but we try to keep it all of Harris County, Montgomery County, Liberty County, and then we others throughout Texas. I've practiced in many counties throughout Texas, but those are the major ones. As far as the mediation, um, the most important thing I would say is to prepare for it. Uh, there's two types of preparation. One is preparing the case as it proceeds so that we have all the information we need to successfully mediate. One thing I didn't mention before is we do a spreadsheet. The law calls it an inventory and appraisement. It's required to be filed before trial, but we always have it at mediation, where we list on a spreadsheet everything in a divorce that the spouses, the couple owns and owes, whether it's community or separate. We have section for separate, separate for community, and we list everything on that spreadsheet, all assets, all debts, anything they own or owe. Now, it doesn't need to be, it's not an inventory in the sense of we want every knife and fork and pan in the kitchen, but we can say if we sold everything in the house at a garage sale, we'd get 10,000 or 20,000, or if it's a 50,000, it's not a garage sale, it's an estate sale. They have estate sales in rich neighborhoods and other neighborhoods that have garage sales. But we put all that, the retirements, the equity in the house, the equity in the vehicles, any investment plans, businesses, whatever they may have. We spend time getting that ready so that at mediation, I have columns for each spouse. So I can move things around and we can tell quickly how this division goes based on evaluating an offer when it comes in and formulating a response to it or making the initial proposal, whatever the case may be. So there's preparation in advance, long-term prep. Then there's the short-term prep that I just talked about of, relaxing, making sure you're off work that day, do not mediate and try to work at the same time. Um, Getting as much rest as you can, having a decent breakfast, and bringing a lot of hydration and something to entertain yourself during the downtime so you're not just sitting there with nothing to do. Those are the most important parts of preparing for it. We do send information to the mediator in advance. And I mean, ultimately, I've done hundreds. And, we're not just we're not just negotiating, we're basically negotiating twice. We're negotiating with the other side via the mediator, and we're also negotiating with the mediator because that's the one we're actually talking to. They're the one coming into our room and relaying what's going on, and they don't just take and pass messages. They explore the issues and they try to say, hey, what about this, what about that, for example, to try to help people get to an agreement. So as far as uh, what I've observed about it, I would say, one, never assume it will be successful or unsuccessful. Don't say this case will never settle, because some do, despite everybody thinking they might not. And don't be certain that it will, because it might not. And be prepared to go with the flow and let the process work and go with the give and take and commit to not leaving until the mediator says we are done. because you never know what's going on in the other room. So when you think it's over, we're never getting a deal, hope is lost, I can't believe they sent this outrageous offer into us, you don't know what's going on in the other room. So you have to trust the mediator to uh, to finally call an impasse if one is necessary, or to say, please wait, we're still working. So that's the best I can say at this point about tidbits about mediation.
Yeah, those are great words, Brian. So, for the viewers out there, could you tell them a thing or two about what sets you apart as an attorney when they're working with you or considering working with you in the Houston and Kingwood, Texas area, please?
Sure. Well, thank you very much for that. Yeah, I've been practicing since May of 1992. Throughout that time, I have always done family law, not exclusively. It's been exclusively since about 2007, I think. Before that, it was probably at least half, at least 50% family law throughout. I also did a lot of civil litigation, which has really served me well in the family law arena because many lawyers who go straight into family law and only do that learn the family code, but they don't really master the rules of evidence or procedure. And they, as I noted earlier, they do apply. Whether they should or not in a family law case is a different question, but they do. And having done a lot of civil litigation and civil trial work earlier, for the first 15 years, I guess, of my career, as well as family law, I learned to a lot more about the rules of evidence and procedure than I think I would have had I done strictly family law from the beginning. But since then, I've done only family law. My staff only does family law, and we're very thorough. I think that's probably the main thing that we do, besides the experience that I bring, is that we try to be very thorough. So that when we're going to mediation, the case is well prepared. If we're going to trial, the case is well prepared. I will often bring, or my associate, either of us, whoever's going to court, will often bring the paralegal assigned to the case. Each case has an assigned paralegal. So person calling knows who to talk to. If the lawyer's unavailable, the paralegal is assigned to the case. We'll know what's going on. We'll be able to update them, give them information, check paralegals. Because they only do family law, can give family law information. They check with the lawyer. If they don't know, if it's appropriate to schedule a call with the lawyer, they will. So we try to always be available for our clients. Of course, like I said, each case has to assign paralegals, so they're available if the lawyer's not. And then preparation and communication is very important. I guess I don't really, I mean, I can tell you that I'm very proud that we have 5 stars on Google and 5 stars on Avo, so I guess we're doing something right. But I try to be very careful on who is on our team and to ensure that they're well trained and know very well how to do their job. So it's a team that works very well together.
Yes, it's very difficult to get 5 stars as a matrimonial attorney in Avod and Google. So excellent work.
It is because um, no matter how a divorce comes out, somebody's coming out with less than they had. I mean, so yes, it's very hard to meet everybody, to meet people's expectations sometimes, because sometimes they have unrealistic expectations. Sometimes they're angry and they think the judge is going to be just as angry as they are and will make their spouse leave with nothing. Like basically their shoes. That's it. Leave this house with your shoes. And it's not going to happen. So that's why it is actually very difficult to maintain 5 stars for a lawyer, especially a family law attorney, because it's just the nature of the business. And we're very proud of that.
And Brian, could you tell us how much a typical mediation costs?
Yeah, no, that's a good question because the most obvious direct cost is the cost of the mediator, and those vary greatly for a few reasons. One is very experienced and well-known lawyers will charge more. Some lawyers are very good at a certain, if they have a background in really understanding retirement accounts, and it's a case that has very complicated retirement accounts, they may just be a more expensive mediator, but usually it's just because of how well known they are and how good of a lawyer they are. So you can spend $1,500 to $2,000 per side for a full day of mediation. I don't know if I've seen 2,000 per side. Probably I've seen 1,800 per side. Probably is the high end, and then a lot of them are at like 1,000 or 1,200 per side for a full day. There's a lot of former judges who mediate. I think they're roughly in the range of for a full day 1,000 to 1,500 per day. That's per side. So that's $3,000 out of the community estate. But it drops because there's lawyers who will mediate for $1,000 for a full day, 500 per side, and then there's of course the larger, as I said, the larger metropolitan counties have usually some type of a county assistance program where they have on staff paid mediators. So then it's a sliding scale based on the party's income, where it can be like $75 per party for a half day of mediation, and those mediators are basically county employees. So there's a lot of variance there. But then you also have the cost of the lawyers, right? Each side has their own lawyer, and if they're there for a full day, that's an expensive day because the lawyers could be anywhere from, I don't know, 300 to 500 an hour, and 300, even if they're both at 300, that's 600 an hour is being spent from the community estate. There's also the preparation. We went through that a little bit, what the preparation is that's involved in getting ready for mediation, but that's hard to specify because a lot of that is the same preparation is done for trial, so it overlaps. If the mediation doesn't work, we're going to have a trial, so a lot of that preparation for mediation is overlapped with the trial prep. It's hard to say, but the most obvious costs are the cost of the lawyers and the cost of the mediator. It is an expensive day because if it's a divorce, all of that money is ultimately coming from the community estate, but it's still cheaper than trial. It costs less than a trial. It gives you more control over the outcome of your case. And if it settles the case and reaches a mediated settlement agreement that's irrevocable, it's a good day. It's an expensive day, but it's a good day because you can move on with your life. So I hope that answers your question as to cost. It varies a lot depending on the cost of the lawyers and the mediators. But relative to people's budgets and resources, they're going to feel it the day. It's not whether you've got a multi-million-dollar estate, you're going to go to some very expensive mediator and have expensive lawyers. And if you don't, you're still going to feel it, even though they're charging a lot less.
It's required because it's going to save time and money in the long run, I suppose.
It's required by the courts because one, it resolves a lot of cases, so it helps clear up the court's dockets. Two, it gives the people a lot more control over their outcome of their case. And three, especially when there's children involved. If we go to court and there's kids involved, we have to put on the case, which means showing what's the best things about my client and the bad things about the other one. And people can be very unforgiving about hearing these things said about them in public in a courtroom. And it makes it hard to raise children together after that, which is another reason that mediation is ordered.
No doubt about it. Well, that 30 years plus of experience obviously speaks volume in terms of your reputation and the ratings that you have online. So it was so good talking with you, Brian. Thank you so much, and great to learn more about mediation. And I hope our viewers find it to be useful information, especially if you do live in the Texas area. We've been speaking with Brian McNamara. If you are considering a divorce or just in need of a consult or additional information, please do reach out to Brian McNamara, and he will be of assistance to you. Thank you so much, Brian, once again for your time, and we look forward to connecting with you again real soon.
Thank you very much for inviting me, Victor.